Welcome everybody to today's webinar. We're dealing with, as we do with cutting edge or significant fair housing topics. I never introduce myself. I don't know why I do that in videos. I'm more focused on the content than myself, but I'm Steve Tomkoviak, Executive Director of the Fair Housing Center, Metropolitan Detroit. I'll be here 6 years, beginning of August. Prior to that, I spent 28 years doing fair housing cases, litigating fair housing cases, through trial and appellate court levels. And I just have a passion and commitment to fair housing because it is so important. All civil rights issues are important. Housing is to me, it's at the top of the list because housing determines so much, right? You go to work and you do things that you can and raise a family. It all really boils down to where you live. So living and fair housing is absolutely crucially important. But enough with the introduction. Hoarding disorders and fair housing. Why do this one? Well, because they're common requests. The two common requests seem to be medical marijuana or marijuana in rental properties, condominiums, co-ops, that kind of a thing. And the other one comes up with hoarding. And I didn't appreciate then what I do now, why hoarding comes up so often. But the purpose of this webinar is to get some answers in dealing with the hoarding disorders and fair housing. And thanks also again to MSHDA for sponsoring this webinar and many other webinars. Without MSHDA, we would not have this training going forward. So thanks so much for MSHDA for doing that. So get into the agenda, and then I'm going to show a real clip video to kind of give us a context for discussions of hoarding and hoarding disorder. So we're going to identify hoarding behavior. There's various levels of hoarding, and then we're going to look at the psychological classification, DSM, and hoarding disorder, and the prevalence of hoarding disorder. We're going to look at then hoarding and fair housing, and then we're going to look at some best practices and resources. So let's start with an introduction. Going to do a very short video.
Welcome back. Many of us know what hoarding is, but what do we really know about why it happens?
Today, we're getting a closer look at the disease from the inside. These are images of homes in Hennepin County. Here you can see items stacked up, covering the floor. There's no clear way through. And in this bedroom, you can see belongings stacked on dressers, narrowly enough room for an entire bed. WCCO's Jennifer Merrily talked with people about the mental illness to better understand it.
Dawn invited us into her Minneapolis home, creating a pathway for us to enter.
How do you just throw that in the trash?
She wants to open the door to allow people to better understand people who hoard.
I've been battling issues with organization and clutter.
She shared she was born into trauma and has battled extreme anxiety and depression.
And so that's quite a joy to have.
She cares about her belongings.
I felt like I needed to be the personal historian of me. How will the world ever know that I was here?
This is a better home space than where it's been.
The pile on the table of paper and such was far, far higher.
So you had more here when you hired the professional organizer.
Yes.
During the pandemic, she was forced to work from home and grew even more isolated. Dawn says it only added to her condition and caused her to buy more.
I developed an obsession with buying Barbie things during COVID as a survival mechanism. I take their pictures and I put them in little scenarios. They became my family during the pandemic because I had no one to turn to.
When you look at your home right now, what do you see?
I see a prison. I become paralyzed with picking up and sorting out what to do.
Therapists say there isn't a quick fix, if you will, for hoarding.
It's really a legitimate mental illness. So we have to kind of treat it as such.
Wade Crandall is the clinical site director at Nystrom and Associates in Hugo.
A lot of times with hoarding, you're also going to see depression, anxiety, sometimes OCD.
Crandall explains sometimes people will hang on to their items as a way to manage trauma, or the behavior can be normalized by a family member who hoards. There are other reasons.
Another big one that we're seeing is people that have been through grief and loss, particularly what we call unrecognized loss. So losses that society doesn't acknowledge, so loss of job, loss of status.
He says during the pandemic, isolation and avoidance exacerbated the issue. In some cases, eviction moratoriums contributed to the problem. Crandall says family members can help, although he cautions against a forced cleanout, saying it could cause people to shut down. He instead suggests being supportive.
Being supportive and just having an open door to your loved ones. If the person could just get rid of it, they would.
Sometimes people are forced to manage their belongings as safety factors into hoarding. Joe Jurisic fields calls typically from first responders.
They'll report that the home is hoarded, and we'll get that call. Then we go out to see for ourselves.
The environmental health inspector in Hennepin County has the enforcement authority to order people to clean up, but says he takes a compassionate approach.
I find it better to work with them and to have them understand why I want them to clean the house. These are people's treasures that they've saved for whatever reason. This is the entry.
He showed us before and after photos of homes, pointing out where the home started and the improvements made.
A lot of cases, huge transformation.
Statistics show hoarding impacts 2 to 5% of the population in varying degrees, or 1 in 20 to 50 people. It can occur at any age, but tends to be older adults who live alone. Dawn has taken steps on her own to take control of her home, hiring a professional organizer.
One of the big goals is to make sure that there's enough space for emergency crews to be able to get in if something happens to me.
She continues to work on her clutter and hopes by talking about it, it will help people realize they're not in this alone.
But it's not a choice. It's not something to be ashamed of.
And we thank Dawn for being so open with us. The Minnesota Hoarding Task Force offers resources online. It's comprised of people who work with people who hoard. You can head to wcco.com/links to learn more. And we are joined by Wade Crandall to talk more about the signs of hoarding and how you can help loved ones. He's the clinical site director at Nystrom & Associates in Hugo and a member of the Hoarding Task Force. Thanks for being with us, Wade.
Thanks for having me.
You know, we know there are different levels of hoarding. Can you talk a little bit about them?
Yeah, so level 1 hoarding is kind of what most people have. You have some clutter here and there. Level 2 is mild to moderate hoarding. Level 3 is more solidly moderate. 4 and 5 are going to be the most severe levels. This is where you're going to have a lot of things stacked up in big piles to the point where they can't open the doors very well. Sometimes you'll have biohazards like rotting food or mice running around because it has so much of that stuff in there.
I know we have pictures of some of the levels. What levels do we have pictures of, Jen? Do you know? But we did have some photos we wanted to call up. But many people fall into that first category. I mean, I come from a long line of savers. I guess I wouldn't use the word hoarding, but we have those tendencies to hold on to things. I'm very nostalgic about random things that I know I'll never look at again. I mean, when does it become a concern?
Well, that's a really good question. I mean, it really becomes a concern when it messes with your functioning. So you can't get in and out of your house. Your social life is being diminished because you're so embarrassed about your place.
And this could be subtle, not to cut you off, but it could be
Yeah.
subtle, like, oh my gosh, my house is just never in shape anymore. Like I could see that being a subtle change for some people.
Absolutely. Yeah. It can be kind of a slippery slope sometimes.
Yeah.
I watch some of those TV shows on hoarding, and there's often a contentious or strained relationship with family members who maybe want to see that change, but they've lost patience. So what is the best step for a loved one to try and, I don't want to say intervene, but guide the person to getting some help?
Well, what I would say is just be that open door to them. So like we can't force people to change. So, what I would say is be empathetic, calmly express your concerns. And then just say, hey, when you're ready to tackle this, I'm here to help you.
It's a good first step. Absolutely.
And it sounds like there are also things that could hurt. I mean, those are helpful things, but there's also some things that could be harmful.
Yeah, I would say one of the things that would be harmful is just saying, just clean it up again. Like I said before, if they could, they would. They got to work on that. Secondly, is I wouldn't offer them storage unit immediately, because that just shifts the problem from the house to the storage
Oh,
unit. It's a
interesting.
Band-Aid. They're just gonna bring in more items.
That's right.
And then don't try to coerce them into a forced clean out, because that's gonna be a trauma event for them, because basically their items are part of their identity.
Hmm.
So that's why we don't want to do that.
Well, Wade, thank you so much for the insight, and Jen, great story. It's an interesting topic that I didn't realize was as prevalent as it really is. So hopefully our viewers got something out of that.
Yeah, that's very, very, very true. I can say personally, there was a family member that has a hoarding disorder, came on suddenly, like later in years, late 50s, 60s. Oh, surprise, never saw any inclination of it. I've worked on cases. I was dealing with someone with environmental, claiming that chemicals in the environment were harming her, and that there needed to be a reasonable accommodation to address that. It was addressed, but in the midst of it, the furnace went down and needed emergency services to do the furnace. And then when the property management company came in, they saw the hoarding, they contacted the police. Police came, and the whole series of events. The person was then institutionalized for a period of a couple weeks to get treatment in that, and then it became a matter of dealing with the hoarding. So certainly it is an issue that we are facing, but I like the fact in that video that the woman, I think her name was Dawn, but came forward willing to share her life and how she feels, really personalizing it and describing others how you have to handle that with compassion and caring. And we'll talk a little bit about that. And then we're going to do a little bit different than what you see in other videos and that. We'll get into the legal issues. How is this handled from a fair housing standpoint? So the Institute for Challenging Disorganization, ICD, has a kind of assessment measuring tool to kind of assess the various levels of hoarding. It was kind of referred to in the video. And you can see here, it has, I should disable those slide transitions. There's 5 levels, and the green color, like it's okay to some extent, is low level hoarding, and it goes from blue guarded. Yellow, it becomes elevated, orange is high, and red is severe. So that's kind of the level. There's descriptions for each of the levels as well as to what these levels consist of. And if you look at, like, for example, level 5, professional organizers should not work alone. In a level 5 environment, requires a collaborative team. You can see social worker, building manager, safety agent. You can see where it's rise to a level that can often result in legal involvement. So it is a continuum for sure. It's very hard to come up with specific numbers on hoarding, and you can see what happens here. So this has the effect on the structure from levels 1 to 5, effect on animals and pets, household functions, health and safety, and whether personal protective equipment is needed. And you can see as it increases on the scale, right, there has to be more PPE equipment available, PPE to take care of this. If you look at, I'm not going to go through it. You can stop the video at any point in time and go through and read that, but you can see the various levels. The key thing we're going to see in a minute is that appropriate steps need to be taken. It needs to be done very much early on before it rises to level 5. Early intervention is very, very helpful. Yes, the PowerPoint slides will be available, certainly. I will post that along with it. But look at I put a yellow arrow there. The individual at level 5 home might be involved in legal proceedings such as conservatorship, guardianship, divorce, custody, eviction, or condemnation proceedings. And formal written agreements among the parties should be in place before proceeding. That is very, very true. If it gets to the point where there's legal involvement, I think of life that way for the most part, right? Couples have conflicts and things, right? But then when it gets to a very serious level, there's legal involvement, right? Legal involvement is not shouldn't be the first step for solving problems. That's really the last resort when something can't be accomplished short of that. The goal is to address the hoarding disorder before it gets to be the level that which legal proceedings eviction proceedings are instituted. That's really the goal. So how is it classified under DSM as a hoarding disorder? It is classified under DSM 5. You can see, I think I want to say around 2015, 2014, it was around that time that hoarding behaviors, there was, became discussion about whether it should be classified as a disorder. And you can see sufficient momentum among clinicians and researchers to regard hoarding disorder as a meriting diagnostic status. For reason explained in DSM and elsewhere, it was nested within a new grouping of disorders, obsessive, compulsive, and related disorders. So that's where it's classified. In the DSM 4th edition, it was listed as a variant of OCD, obsessive compulsive disorder, which had already been the subject of claims for workplace accommodation, often for tardiness and absenteeism. I think hoarding is more of an issue when it comes to housing, obviously, than employment, although I've seen hoarding in employment. I could show pictures, but but the idea is that it does happen. It really does happen. And here's the actual table for hoarding disorder, and you can see it lists the factors, right? Persistent, it's obsessive compulsive related disorders, persistent difficulty in discarding or parting with possessions, regardless of whether they have value. And it's very, very stressful, right? It causes clinically significant distress or impairment in social, occupational, and other important areas of functioning. The video kind of showed that, right? It has an impact. It's not just, you could kind of think it's just the person dealing with it, but it's not. It affects other tenants. It can affect, management staff. It can affect other family members quite a bit who are there stressed and trying to work with it, how to take care of it. And then another one, hoarding is not necessarily attributed to another medical condition. Typically, it's not. It's a standalone type of mental illness or disability, and it's not better explained by symptoms of another mental disorder, right? So clearly, the bottom line is this: hoarding is a covered disability. We'll see that in a second. What differentiates hoardings, and I have a psychology background, but what differentiates hoarders from other people who are simply messy is that their living spaces can no longer be used as originally intended. I think of it as problems in living is a really kind of a functional definition, right? When it affects someone's daily living. And I'm not talking about clutter and mess. That, everybody has various levels of that in their lives. That's not the issue. But if it begins to impact how someone can use their home or where they're living, then it becomes more of an issue, right? Moving through rooms, goat paths, they use that term. Narrow trails not more than a foot wide where the floor is occasionally visible, right? And it can be more than just clutter. It can create unsanitary health issues within their home. There is stress that goes along with this. Stress on the person, stress on children, other family members. It can affect someone's social functioning. Like you saw in the video, they're reluctant about having someone come to their home. So it leads to a level of isolation. And based on its manifestations, compulsive hoarding often causes substantial impairment of major life activities for those afflicted. So that's a real good description, right? And what happens? Tragically, right? The traumatic experience comes when public health officials, management, others come in there to move and to clear out their homes. And that's really what looks like trash to some, to the outside person, to the third party, right, is not viewed that way to the person who is has a hoarding disorder, right? And it just to step in aggressively and manage a situation may not really work. It could cause even greater degree of stress and anxiety. And look at the bottom. Forced cleanouts are expensive and do not treat the root of the hoarding problem, the behavior that causes the disability. So here's what kind of shocked me with this, because it came up all the time, not all the time, but a lot of times in fair housing trainings What to do about hoarding? Oh, talk about hoarding. Can you talk about hoarding? I'm thinking, well, why would someone ask about that? Well, the reason is it's hard to get a specific estimate. You look at the bottom here, that's the kind of the data that they showed on the video. Prevalence of hoarding in North America is approximately 2 to 5% of the population. Some list it higher. Some say it can be up to 5.5%, and the lifetime prevalence up to 14%. Another report is that 6 million to 15 million Americans suffer from hoarding, causes them distress or interferes with their ability to live. That's why the question comes up a lot, because it is a problem, or I shouldn't say problem in that kind of sense, but it is something that frequently occurs. It just does. But I was just shocked. I don't know your reaction to this, but the absolute numbers and percentages of people that have hoarding disorders just shocked me. And now I can see why the question came up so often. So let's get into, just briefly, hoarding and fair housing. Oh, the question is, are there any sources of information more recent than 2010? I didn't see any. Good question. Good question. I would like to see what the current data is. I doubt if it's changed a lot. I would say, I think the question kind of implies it, right? Is it possible that it has increased? I suspect there may be actually an increase of hoarding. And I think too, the pandemic caused, like that video showed, it caused because of isolation through the pandemic, right? Had people staying in their homes, kind of isolated, which even led to more instances of hoarding disorder. So how does hoarding connect with fair housing? Kind of goes, how do we see it? What's the implication, right? You can look at it. It can be in a rental context. It can be a violation of lease occupancy requirements, and you can see some of them on the left. Failure to dispose of waste in a timely manner, destroying, impairing any part of the premises, the rental unit, maybe even a common area, disturbing other neighbors, or neighbors claiming smells, odors, that type of a thing. And it can be a violation of building and housing codes. Some of that are written into the lease. They can be implied into the lease as well. There's also an issue as to compliance with state and public health codes. There's sanitation requirements. There's restrictions on storage of garbage, presence of pests and other rodents. And then it can be a fire hazard, and there's medical hazards that can also impair someone to leave a building in case of an emergency. And results of it can be what? Fines or condemnation of property, injuries to the hoarder's health, even the health of other tenants, the health of the family of the person with the hoarding disorder. And you can see here highlighted filing of eviction actions. And for some, they result all the way through homelessness. And there can also be a claim that compulsive hoarding is a covered disability under the Fair Housing Act. We'll talk about that, requiring that tenants with a hoarding disorder be granted a reasonable accommodation to address the circumstances that gave rise to the hoarding and then ultimately ended up in the actual or threatened eviction. So hoarding as a covered disability, the Fair Housing Act defines disability in Section 802H, or codified at 42 United States Code, Section 3602. HUD has more detailed in the Fair Housing Implementing Regulations. We'll see that in a second. In Note 2, the Fair Housing Act uses the term handicap instead of the more commonly accepted term disability, but from a legal standpoint, both handicap and disability have the same legal meaning. I prefer, obviously, use the word disability. And here's the definition under 802 or 3602H. Handicap means a physical or mental impairment. This would be a mental impairment in this situation that substantially limits one or more major life activities. It could also be someone has a record of such an impairment or is regarded as having such an impairment. So that's a broad definition of disability under the Fair Housing Act. HUD's regulations are much more detailed, and you can see, referring again, it starts off by quoting the Fair Housing Act. Physical and mental impairment substantially limits one or more major life activities. Physical or mental impairment includes any mental disorder, right? Emotional or mental illness. And you can see, so it deals, just a broad general term, covers any type of emotional illness. And you can see that hoarding easily would qualify as a disability under the HUD regulation and under the Fair Housing Act. So in looking at reasonable accommodations, two sources. The main thing is the HUD regulation 24 CFR section 100.204. That was on the previous slide. And HUD, DOJ, Department of Justice, and HUD have a joint statement on reasonable accommodations under the Fair Housing Act. It doesn't, neither of them specifically mention hoarding, but the general principles as far as reasonable accommodations apply. One thing just to be complete, there's additional policy statements. HUD has a policy statement on assistance animals, and DOJ has an FAQ on questions about service animals and the ADA. When it comes to municipalities, HUD has a HUD-DOJ joint statement on state and local land use and practices on applications of the Fair Housing Act. And you think, well, what's that got to do with hoarding? Well, a municipality may want to address a home, right? Enforce their code violations or alleged code violations when it comes to a residential home where hoarding is occurring. And I just emphasize this, I got a contact from a city attorney just recently. They didn't think the Fair Housing Act applied to what the city was doing, because I don't know why someone would think otherwise, but absolutely the Fair Housing Act applies to state, applies to local zoning departments, cities, villages, townships are all subject to the Fair Housing Act. It's a little bit different when it comes at the state level. There's 11th Amendment immunity, so it's a little bit different when it comes to the state, but most zoning issues are at the local level anyway. So they are subject to the Fair Housing Act. Someone can make a reasonable accommodation request as to, to a code official or building department when it comes to needing time to address their hoarding disorder. So that would be something that, so this would be important, even from a municipality standpoint. Here's an example of the HUD regulation for reasonable accommodations. Again, these are examples, but it really doesn't get into the specifics about hoarding. So what I did is I, did quite a bit of research looking at hoarding and fair housing to see how it's being treated in cases. Came up with a couple cases, not very many, surprisingly, but I came up with a couple, and it kind of gives some guidance into how hoarding can be dealt with from a correctly, right, or incorrectly from a fair housing standpoint. So here's a couple case studies. The first one is Smith versus Hillside Village. It's a 2017 case. And there, Ms. Smith was 78 years old. She is in a rent-controlled apartment unit. She lived there, for 51 years, a long time. And then at some point in her life, as she aged, she became depressed and developed hoarding disorder, and her apartment became extremely cluttered. In July 2015, she let emergency personnel enter her apartment. Someone had said that reported an odor of gas. The source was found to be her clothes dryer. Emergency personnel noted the hoarding conditions and other structural problems with the unit, issued a notice of code violations, and noticed that the apartment could not be occupied until the conditions were remedied. She claimed she moved her possessions to alleviate the hoarding and to permit repairs. Since then, she has resided elsewhere, but she has no home of her own. What happened here is on July 2015, the housing provider Hillside Village issued a 3-day notice to quit. It's cited for the grounds for termination of the tenancy, hoarding, and failure to perform basic housekeeping activities, but not the structural defects. Not the best notice to give, right? Should you cite hoarding when hoarding is a covered disability? I don't think so. But anyways, they did. And if you look at the bottom, footnote 7, well, I'll get that in a second. So anyways, Smith's counsel, through Shedd attorney, presented Hillside with a proposed plan of action where she would get counseling, take medication to address her condition, and arrange for monitoring of her unit by a support organization. Sounds like a good plan. And then she asked that she have permission to resume her occupancy under those conditions. And look at footnote 7 there from the court decision. She alleges she specifically directed Hillside to the May 7 joint statement of HUD and the Department of Justice. That's why I mentioned that earlier. It's really, really important. Even though it doesn't specifically address housing, it does address ways that reasonable accommodation requests can be requested and how the housing provider should respond to the request. And again, I would say the same thing for a municipality. So Hillside rejected that proposal for reasonable accommodation and did not permit her to reoccupy the apartment. The trial court right, ordered Smith's eviction. The appellate division on appeal reversed the decision, so overturned the eviction, but still Ms. Smith was not restored to occupancy. So the federal court complaint filed by Smith asked for an order compelling Hillside to repair the unit and restore Ms. Smith to possession, and they also asked for money damages. So how do you think it would work when this went into federal court? Again, in the state court proceeding, Ms. Smith originally lost at the trial level, won in the Court of Appeals in New Jersey, but then they did not allow her to go back into her unit. So that's why she went ahead and filed a separate complaint in federal court for denial of a reasonable accommodation. And here, the court noted they wanted to have the Hillside wanted to have the federal court case dismissed. And here's what the court found. Ms. Smith made significant efforts to assert her rights under the Fair Housing Act in the only context where it mattered in connection with the landlord-tenant action that resulted in her eviction and subsequently overturned on appeal. She directed Hillside to her rights under the Fair Housing Act, it says FHAA, that's the Fair Housing Amendments Act. That was when disability got added to the Fair Housing Act in 1988. And so sometimes it's referred to the Fair Housing Act from its original language when it was passed in 1968. But Fair Housing Amendments Act includes adding disability and familial status in 1988. So any disability-related claim really arises under the 88 amendments to the Fair Housing Act. So that's why it says Fair Housing, FHAA, Fair Housing Amendments Act, referring to the Amendments Act of 1988. So anyway, she directed Hillside to her rights under the Fair Housing Act, as amended in 88, sought to consult with Hillside's counsel, and proposed a reasonable accommodation consisting of treatment of her disorder and monitoring of the apartment by an outside agency. The appellate division acknowledged that she attempted to raise the fair housing claim, at least as a defense, if not a counterclaim, in the landlord-tenant action, but she was rebuffed from doing it. So the bottom line is she could proceed with her reasonable accommodation request to accommodate steps needed to address her hoarding disorder. So the way Smith handled it and through her attorney, they took the right steps. Hillside Village, the most prudent approach, work with the person, right? It looked like a solid plan to address the hoarding disorder. Let's say the plan works. Good. Ms. Smith can remain in her unit. If the plan does not work and she doesn't meet, the terms of the treatment and addressing the hoarding, then eviction then would be an appropriate result. But that's how it should work. Just surprising Hillside Village did not work with her. And surprising too, that state courts didn't really consider the fair housing claim, although maybe I shouldn't be that surprised. State courts often, they do not, they don't have the experience as federal courts do typically in handling fair housing cases. And then another case I found, Westfield Senior Citizens Housing Corp versus Lytel, again out of New Jersey. And it said that a reasonable accommodation defense to an eviction is available only if tenant suffers from a disability, landlord knew or should have known of the disability. Accommodation is necessary to give the tenant an equal opportunity to use and enjoy the apartment. The tenant requests a reasonable accommodation and the landlord refuses to grant it. Some courts have a slightly different standard. The two key things are necessity and reasonableness. Necessity means that the tenant has a disability and the reasonable accommodation is necessary to address the tenant's disability-related needs as far as housing is concerned. And then reasonableness has to do with the burden, expense on the housing provider, on the landlord, on the management company. Those are the two key things, necessity and reasonableness, right? And number two, the landlord knew or should have known the disability. The way that's usually covered is this. In order to have a reasonable accommodation, you have to make the request. If you make the request, you got to notify the landlord what your disability is. Sometimes it's obvious if someone is in a wheelchair. Other times it's not obvious if it's kind of an emotional illness. Is not readily impaired, in which case, again, it's incumbent upon the tenant to make sure the landlord understands it. The reasonable accommodation request can be orally, doesn't have to be in writing, doesn't have to be on housing providers' forms and whatnot, but the recommended approach is to always put it down in writing to avoid any miscommunication or misunderstanding. So here in Westfield, the appeal concerns the third and fifth prongs, isn't it? Regarding the nature, again, I'm not necessarily agreeing with the elements here. I think it could be phrased better, but we'll go with this. Regarding the nature of the accommodation, in other words, dealing with the necessity part, point 3, and whether the landlord was required to provide it in the manner the tenant sought. So here, the court found the tenant, they agree with the trial court, tenant requested reasonable accommodation, and the tenant's hoarding disorder constituted a disability, which the landlord was aware of, as indicated by the landlord's prior efforts to address the hoarding conditions in the unit, and actually parties entered into a 2011 settlement agreement. And so what happened here, the judge have become increasingly amenable to finding that a handicapped tenant is entitled to protection under the Fair Housing Act in a form of reasonable accommodation, if necessary, to maintain their tenancy, and an equal opportunity to use and enjoy the dwelling as enjoyed by people who do not have a disability, right? An accommodation, right? Reasonable accommodation could be asking for a stay from an execution of a warrant of eviction or halting the eviction proceedings. However, accommodation based on recognition of a disability hoarding, which is directly related to the complained of behavior and of which a supportive housing landlord is aware in advance of an eviction proceeding, is a rational extension of this trend. So the court does recognize in New York that hoarding can be as a covered disability and someone can make a reasonable accommodation request. To this end, more specific pleading is a modification to practice and or procedure that could assist the hoarder to maintain and enjoy their dwelling. So what did the court basically want? The court wanted more detail in terms of what the request was, what kind of information was needed. So the court found that it was covered under DSM 5 as a covered disability. And here's where some of the more guidance comes from the court. They cite a recent study in Psychiatric Services, April 2020, talked about how, is a pilot study to address gap in treatment for individuals with hoarding disorder, and they're providing low-cost, flexible, and time-limited community-based program to improve quality of life and prevent eviction. And here's the key thing, right? While they're conceded, while there was statistically significant decrease in the level of clutter through early intervention, level of clutter is still severe enough to put the clients at continued risk for eviction. Meaning what? If someone seems like they're developing a clutter disorder, don't wait. Address it early on. Waiting till it gets to be level 4, level 5, I mean, better address it then than never, but ideally it should be addressed early on. And here's what the court emphasized: because hoarders experience distress at the thought of getting rid of items, specific instruction regarding how the respondent could cure the alleged breach of her obligation falls within the rubric of early intervention. Meaning the court is saying, hey, housing provider, give some specific guidance as to what the person with the hoarding disorder needs to do. And here it wasn't clear, right, according to what the court found, that the housing provider did not make it clear whether the tenant needed to remove everything or whether removal of recyclables in some boxes would prevent the eviction. And it said, basically requiring attorneys to plead with more specificity and notices to cure served upon supportive housing clients who suffer from a hoarding disability would be an inexpensive accommodation in the form of modified procedures prior to commencing an eviction proceeding, and may lead to more expeditious compliance with a notice to cure. Very interesting approach. So what basically the court is saying is almost saying a good idea is a pre-eviction notice to give a written list of what exactly the housing provider would like the tenant to do, or feels that the tenant needs to do to address the situation within the unit specifically, right? And that's a good first step rather than simply, right, giving an eviction notice and filing an eviction case, right? Address it early on, give a detailed notice as to what the tenant needs to do to continue with occupancy. Here was the claim for nuisance, right? The notices that the housing provider gave in this case didn't give any notice or allegations as to how the alleged conduct negatively impacted health and safety of other tenants in the building, right? And it didn't lead to reasonable inference that the alleged clutter, right, jeopardized safety of other tenants, right? The court has found notice of termination hoarding cases when there are allegations of, for example, vermin, insects, foul odors, fire threats, which common sense dictates can affect the entire building and are spread to other residents' apartments to be sufficient. However, here there are no such allegations, and the kitchen, usually the greatest fire threat, is specifically exempted from the complaint. So the court is doing what? Making sure that the notice going forward with eviction really spells out the nature of what the right factors are to give rise for it. Here it was based on nuisance, eviction over nuisance. That's under New York law. But make sure, right, prior to commencing eviction proceedings to spell it out. And even in the eviction complaint should be very, very specific and accurate. Can't just make up stuff. Has to be very, very accurate, have pictures, have it supported so that if it goes forward in court, that those items will be addressed. But early on intervention is key. Another case, again, there weren't a lot of hoarding cases, surprisingly. This one came out of Connecticut, right? And here has that same factor, dealing with the immediate and serious danger of safety of other residents. And here, right, the records show that the condition of the unit would impact in a major way the safety and health of the other tenants. There were photographs taken. There was testimony that there are piles of garbage and dishes with rotten food scattered throughout the unit. The sink and toilet were inoperable because they were clogged. The oven and stoves were covered in grease, presenting a fire hazard, right? The ample evidence support the trial court's conclusion, eviction court's conclusion, that the condition apartment was squalid, unsanitary, and a public health threat to other tenants. And that presented immediate and serious danger to the health and safety of other tenants. So the court found that the conduct constituted a serious nuisance consistent with Connecticut law. So that's again, good guidance as well. Another case study, again, I'm sorry, this one, a little bit more detail on this. After filing the appeal, the defendant wanted a motion for articulation of the court's decision and wanted to know whether the landlord, housing provider had reasonably accommodated defendant from January to May 2019. And what happened here, the court issued, trial court issued a more detailed explanation on February 6th, explaining although there was no evidence in the record that defendant ever requested a reasonable accommodation, the plaintiff, the landlord, had nonetheless attempted to accommodate the defendant. Again, on appeal, the defendant not raised a claim under Americans with Disabilities Act or any other state or federal law. A residential unit typically is not subject to the ADA. It's only subject to the Fair Housing Act. The ADA covers place of public accommodation, meaning open to the public, right? There has to be 12 specific categories. A residential rental unit is not subject to the ADA. So the ADA doesn't apply, right? So it's a little bit of a mistake there. But again, the courts are looking at whether or not a reasonable accommodation request was made. Doesn't mean you have to accommodate someone who doesn't make a request, but best practices is see if there is a way to address it short of immediately filing for eviction, then dealing with the reasonable accommodation request. I hope, these cases give some guidance on what housing providers should do. Just for completeness, under the Fair Housing Act, there is no right, there's no coverage for someone whose occupancy tenancy constitutes a direct threat to the health and safety of other units, or whose tenancy could result in substantial physical damage to the property of others. That's a direct threat exemption to the Fair Housing Act. And you can see it has to be considered when you talk about hoarding, because if a hoarding disorder results in what? A threat to what? To the health or safety of other tenants, right? Or could result in substantial physical damage to the property, the rental unit, then there is no coverage under the Fair Housing Act. And you can see HUD regulation, implementing regulation, kind of quotes the Fair Housing Act. In the proposed rule, they make clear, however, that this direct threat exception was not intended to create or permit a presumption that individuals with handicaps or disabilities generally pose a greater threat to health or safety than others who do not have a disability. Has to be based on objective evidence. They also, in the Congress, in implementing or in enacting the Fair Housing Amendments Act in 1988, cited the direct threat. And Congress said in the House report that direct threat exemption should be interpreted consistently with the Supreme Court's decision in School Board of Nassau County versus Arlene, right? And it says basically the direct threat exemption under the Fair Housing Act incorporates Arlene standards, meaning what? The court in Arlene said that had to deal with contagious disease of tuberculosis, saying that can be an individual with a handicap. However, if an employee poses a significant risk of communicating a contagious disease to others in the workplace, then they're not otherwise qualified for his or her job if a reasonable accommodation will not eliminate that risk. If there is a reasonable accommodation that could eliminate the risk, entities covered by the act are required to provide such an accommodation. Meaning what? If someone occupying the unit, right, and it's causing a direct threat to the health and safety of other tenants or to the damage to the unit, that does constitute what? A direct threat. However, could the reasonable accommodation alleviate that direct threat? If the answer is yes, probably the answer will be yes, then you can't rely on a direct threat exemption. Must first find a way to address the condition affecting the health and safety of other tenants or damage to the unit, and then right through the reasonable accommodation specific plan to address the situation to eliminate that direct threat. Otherwise, if it wasn't that way, then any person with a hoarding disorder, aha, it's a direct threat, get out, right? That's not what the law says, right? That school board, Nassau County, the Arlene case said what? Find a way to see if the reasonable accommodation will eliminate that risk. That's a good standard. Also, there's language in the House report. Subjective fears, assumptions, speculation fail to satisfy the direct threat exemption. It has to be made on specific facts. You can't just say, well, anybody with a hoarding disorder is going to cause, issues or risks as to the health and safety of others and may cause damage to the unit. Therefore, hey, they got to get out. No. Has to be based on objective evidence that that is actually occurring and that it can't be addressed through other means, such as working with someone on a reasonable accommodation. So here's a good quote for this one. This is a great Rutgers Law Journal article on hoarding. Luckily, federal courts have interpreted the Fair Housing Act to hold that this direct threat exemption does not come into play until after the trial court has evaluated a landlord's response to a requested accommodation and has determined that no reasonable accommodation could ameliorate the situation sufficiently to protect the health, safety, and property of others. Well put. It also cites a Howard versus Beaver Creek case out of Sixth Circuit. So what are the best practices? Right, real important, and we can give some specific guidance here, which is so helpful, right? If a person suffers from a hoarding disorder and being evicted because of behavior related to the hoarding disorder, person can ask for reasonable accommodation. Reasonable accommodation, what? Making exception as to the lease provision that would otherwise require eviction. And usually it will involve asking for more time to obtain appropriate supportive and mental health services that allow the tenant to bring the unit into compliance and then satisfy the lease provisions or policy. Now, while a housing provider can deny a reasonable accommodation request if the tenant's behavior poses a direct threat to health and safety of staff, other residents, or the property, or cause substantial property damage, and a reasonable accommodation will not minimize or eliminate the threat, then it can be denied as a direct threat, right? However, before doing that, hoarding can give rise to this. Fair Housing Act requires housing providers to consider a reasonable accommodation plan from a tenant that could minimize or eliminate the threat of the hoarding behavior while allowing the tenant remain in their housing. And by the way, too, just because a reasonable accommodation request is not like an up or down vote, grant the reasonable accommodation request, deny the reasonable accommodation request. There should be an interactive process between the tenant, the landlord, the housing provider, and others to come up with a plan that's agreeable to everyone, right? Doesn't mean you can't ask for modifications, doesn't mean you can't, on the plan or come up with a different time frame. Again, you want to make it should be viewing it, you can view it from the tenant standpoint, you can view it from the housing provider standpoint. The question is this: is the housing provider finding a way to work things through so that the tenant can remain in the unit? If that's the approach and that's how it's being done, that's not a fair housing violation. It's when they're looking for reasons, had enough, we would just want that person out, right? Then it looks like what? That looks like discrimination. They're trying to find a way to get the person out of the unit. That's where the violation occurs, right? I like the suggestion here, successful reasonable accommodation plan, especially with hoarding disorders, collaboration between the tenant, housing provider, mental health professionals, social workers, and other advocates. We've had people, I've even done it where I've made some calls and gotten social workers and that involved, right? It should be a collaborative group of professionals to address it. The video showed that a little bit. That's the best approach. There is, I thought I had it here, there is case law basically saying that the landlord, property management company is not a therapist. You don't have an obligation to treat a tenant. That's not your role. It's not your place. However, you do want perhaps mental health professionals to get involved to assist in addressing the hoarding disorder. When other family members, friends, other mental health providers get involved with it, the likelihood of successful in treating the hoarding disorder will increase. So that's a good approach. Other suggestions, kind of mentioned it, early intervention. Please do not wait thinking it's going to get better by itself. Probably it will worsen, right? If you address it early on before it's a major problem and get into some of those and get treatment, it can be much better, right? When it comes to reasonable accommodations, at times you may need to consult with legal counsel from both sides, from the tenant or from the landlord, housing provider side, to determine the scope and what's appropriate in terms of reasonable accommodations. The goal is to do what? Have a safe living environment without disruption or minimize disruption to other tenants or violating health and safety regulations. Referrals and support, connect residents with hoarding disorder to appropriate mental health professional support groups and local service agencies specializing in treatment of hoarding disorders. Another key one too, amazes me, why did things get so bad before it's even seen, right? Conduct periodic inspections of property to ensure compliance with health and safety standards. You must do that. Maintenance staff are crucial. Do it. There should be an agreed upon inspection schedule. Our law in Michigan, other states as well, permits it. You may want to spell that out in your lease, but that way you won't suddenly be surprised, right, years down the road that there's major hoarding occurring in that unit. It shouldn't take that. There should be regular inspections. I'm not saying you go there every other day, obviously not, but there should be a schedule of periodic inspections. Like I said, the cases that I've been involved in is where something happens, fire goes out, or a furnace goes out, or something, there's a problem with the plumbing. So, contractor has to come out, repair the plumbing, and then they discover the hoarding. So you ask yourself, why wasn't it looked at earlier, right? It's not in anybody's interest to wait and address it when it's a major problem. If it can be caught early on, that's the best approach. And then the last part, maintain comprehensive records of communications, inspections, and any actions taken to address hoarding related issues, right? It's crucial to show good faith efforts and compliance with fair housing regulations. These are all solid best practices in dealing with tenants with a hoarding disorder or suspected of having a hoarding disorder. This is one example of a county health department little checklist here. It's got hoarding, excessive clutter, and you can see the list of items here. Items in red subject to immediate place carding as unfit for human habitation. And you can see these. is this list dealing with someone who's a hoarder, or is it dealing with health and safety issues? It should be the latter. We're not, and no one's advocating treating someone adversely because they have a hoarding disorder. Hoarding is a protected disability, certainly. However, it is in the interest of, right, the landlord, owner, property management company, health department, municipality to make sure that health and safety items are addressed. If your focus is on health and safety and what steps to give somebody sufficient time to address this, then you're doing the right approach, right? A reasonable opportunity to address it. And you can see the health department dealing with owner occupied property, rental property, and so forth, right? Dealing with those types of issues. So this should be helpful, right? We have millions of people with hoarding disorders, and we need to find a compassionate way to get early on intervention and assistance so that people can maintain their housing while addressing the circumstances, the emotional factors that have led someone to then be now suffering or being afflicted by a hoarding disorder. Now, the goal is to do what? Make an improvement into somebody's life, right? That's the ultimate goal. Sadly, sometimes people go so far as homelessness or they're evicted and they lose all their items. Man, imagine the distress and turmoil that occurs if that happens. So positive solutions to a difficult problem that affects millions of Americans. The cluttered apartments and complicated tenancies is a collaborative intervention approach to tenant hoarding under the Fair Housing Act. Suffolk University article is very good. And the Kenneth Weiss and Nia Khan hoarding housing in DSM 5. Not that there should be much dispute about hoarding as a covered disability, but they go into good detail explaining why it is covered. And then the last thing is another, it's a Redford's Law review article, Navigating the Past, Goat Paths, Compulsive Hoarding, and Collier Brothers Syndrome. Collier Brothers were famous for hoarding. I think they were in New York City, just a famous case of hoarding and the legal reality of clutter. So those are some of the resources. So anyways, I hope this has been helpful.